Well, hello there to all the good people of Ohio and beyond. This is Aaron Knapp, and you're tuned into Unplugged, broadcasting without permission. This is a place where the truth gets louder and we dig deeper, and where we always remember be lawful, not awful. If you want the full stories, the documents, the videos, and everything they don't want you to see, head on over to AaronKnappUnplugged.com, my new home for every investigation, every episode, and every update. And while you're here, be sure to like the video, follow the page, and hit subscribe, and share this with someone who needs the truth. We're building something real here. We're building something fearless, and we're doing it together. Welcome to Unplugged. Let's kick this thing off.
Plug with Nap. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Nap. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We
down to all of our departments and assure that as part of our regular checklist that we have for many projects, that we can visit this. This is not a common area because we typically don't waive fees. So it's one of those areas that we'll revisit here as we move along.
Thank you, Mr. Carrigan.
Anything? Say something? Then why are we?
Mr.
Say something? Then why are we? You want to get an
Mr.
attitude? You work for me, carry on. Yeah, get it. Do it.
Mr. Knapp, let's have it.
No, your employee is addressing me, sir.
Hey there, good evening, Lorain City, Lorain County, Cleveland, and beyond. Anybody out there that's watching tonight, we welcome you here to Lorain Politics Unplugged, or Politics Unplugged with Aaron Knapp. That's right, folks. We're here to discuss what's been going on lately. Tonight, we're going to do a long haul podcast on my story. Everybody's always asking, why, who, what, when, where, why. They're always not really understanding where everything comes from. I'm hoping tonight we'll answer that. Bear with me, and we'll get through all of this. But I've got it kind of scheduled out, so hopefully we can get through this with some a little bit of a regularity, I guess. But this is where my story, and it's kind of, this is where it starts. Like, the story is about me, but not the version of me that was passed around or has been passed around in emails. Not the version that gets written into internal reports, or the version of the people in positions of authority have tried to turn into something they needed to control, right? It is about who I actually am, what actually happened, and how something that should have ended in a simple conversation turned into years of escalation, retaliation, and legal battles that I never went looking for. Now, before any of this started, I was not looking for conflict. I was a veteran who had already done my time serving this country. I had come home. I was carrying injuries that do not just disappear when the uniform comes off. I rebuilt my life the only way I knew how, and by putting it into the work. I went back to school. I did not take the easy route. I was accepted to Ohio State, and I commuted every day from Avon Lake. And I was and am still a single father at that time, balancing school, parenting, and everything else that comes with that, trying to build something stable after the military for me and my daughter. And it wasn't a part-time effort. It was years of work, long drives, a lot of audiobooks, long days, and a commitment to finishing what I started back in 2016, I think it was. So by 2022, I had earned my degrees. I had my minor, or first off, I had my associate's degree, which would have been in criminal justice, but ended up being in liberal arts because I want to pigeonhole myself. Then at OSU, I got a degree, a minor and a major in social work with a minor in drug and alcohol education. And that was my intent of doing exactly that, what the field's supposed to be representing, helping people, holding systems accountable, and making sure that people who are suppressed or supposed to be protected, I should say, actually are. That's who I was when I started all this, when it began. That part really matters because by 2026, everything you're about to hear, the Department of Veterans Affairs made a determination, as I've said recently, about my condition. They didn't just say I had PTSD. They ruled it permanent and stationary, and they determined that I was no longer able to work. That did not happen in a vacuum. That came after years of pressure, years of escalation, and years of being pulled into situations that I never should have existed in the first place. Thank you, Lorain. All that work, all that time in school, all that effort put into build a career in social work, and effectively it was just stripped away for nothing. Not because I failed, not because I walked away, but because the situation I was put into kept escalating to a point where the VA itself stepped in and determined I could no longer maintain, employment. That is the cost of what you're about to hear. I mean, I hope Lorain Police is proud. I hope Jack Bradley and everyone out there is proud. I hope you guys are proud of yourselves. You're amazing because you did this. Look at your work. This is your handiwork. All that down the drain, taxpayer dollars. But you're used to burning those, right? And it didn't end when the person that most people would point to, Chief McCann, was no longer in that position. The one that did it. The pattern didn't stop. The pressure didn't stop. The narrative didn't stop. It continued, just under different names, different titles. When it started, Ray Carrion was my sixth ward councilman. He had knowledge of what was happening from the beginning. He was part of the environment in which this was unfolding. And as time went on, his role expanded. It changed. It grew bigger. And he became a safety service director. With that role came more authority. And again, recognize all the conversation I'm having right now is about my safety service director, not the individual person, right? We're speaking government here. With that role came the authority, the control, that ultimately a position where he was directly involved in investigating the very situation he had already been aware of and been my advocate in. So at one point, it was Sanford who was the safety service director and Ray was my advocate. Well, that progression matters, right? Because it shows continuity. It shows this was not just something that came and went with one person. The same names, the same awareness, the same involvement carried forward as positions changed. Before I ever walked into City Hall for the incident that we all now point to, my first incident was Swanger, or at least I point to. I'd only been there one time. That was the first visit that had nothing to do with causing problems. I went there to speak to the mayor about concerns I already had about, involving Chief McCann. At that point, my interactions with the police department had been minimal. They'd been limited to, you know, issues between my kid, having seen stuff and things happening. But I started noticing things that didn't sit right with me. And that's what social workers are supposed to do. There were officer engagements in my neighborhood that raised questions about how situations were handled. There were interactions that didn't quite match with what I understood professional policing to look like. At the same time, I was paying attention to what was happening publicly. I was commenting online about the Hildreth matter over on West 32nd Street or whatever it was, a situation that had drawn attention in the community. I was watching how the Lorain Police Department was managing their public presence, their Facebook page, which was open to public, which suddenly was restricting access to comments. People were being blocked from participating in discussions about government activity. By people, I mean me as well. And that stood out to me because once a government entity opens a public forum, especially online, it doesn't get to pick and choose who it lets speak without raising serious questions about fairness and transparency. Now, I will say there's been some recent law changes that allowed them to shut down their page or do certain things, but especially at this time, that wasn't really allowed at all. And so by the time I went back to City Hall that second time, I was not walking in as someone looking for a fight. I was walking in as somebody who had already started asking questions, someone who had already engaged in protected activity by speaking out, commenting, raising concerns about the government conduct. And that's important because it establishes what I was doing before anything else escalated. That second visit, it changed everything. And it was only my second time ever being in Lorain City Hall. Not a pattern, not repeated visits, not some history of disruption like they later tried to suggest. My second time. And I walk in expecting to handle my basic business, ask questions, request documents, and leave. But at the checkpoint, I did what everyone does. I placed my belongings in the belt, prepared to go through, but nothing unusual. But I was told to put my wallet on the scanner, and that immediately stood out because I was like, well, that's not something I've experienced before. I was like, well, I've been through more secure environments than most people, military installations, airports, courthouses, places where procedures are so strict, but also consistent. A wallet is never treated like a weapon. It is not treated like something that needs to be scanned through like contraband. So I asked the question, as I always do, not aggressively, not loudly, not in a way that should have triggered anything. I asked why. I even tried to cooperate in a way that made sense. I took the wallet out, opened it, showed them what was inside, offered to let them inspect it manually. I just replaced some of my bank cards, and I really didn't want them damaged by an old machine. That's not resistance. That's a reasonable concern paired with reasonable alternative. That is where everything broke. Instead of getting an answer, instead of someone explaining a policy or even acknowledging the question, the situation escalated. And what it turned into was um, something different. It became, hold on, something that should have never happened. The auxiliary officer left his post and went to his locker, and he came back holding something that should have not even been introduced into that environment at all. It was a credit card knife. He opened it, he displayed it, he used it as a demonstration to justify why wallets needed to be scanned. I understand the mentality, but in that moment, the entire situation stopped making sense. We were standing in a building where weapons were not allowed, and the person enforcing the rule had just introduced one to make a point. My reaction was immediate and instinctive. I stepped back, startled, because anyone would be. I told him I did not need a demonstration, that a verbal explanation would have been more than enough, because it would have been. But before I could even process that, a lieutenant entered and placed his hand firmly on my back. That was Swanger, our new dog catcher. And it wasn't a light touch, not guidance, but pressure that moved me back. Actually, it moved me forwards, back towards the guy. I asked him why he was touching me. I asked more than once. There was no answer. The only response was continued pressure, continued movement, and a clear signal that the conversation was over. I ended up being like the guy said some stuff to me about being close to his guy, and then which I wasn't, and then I grabbed my stuff, and I kind of ended up being forced back over by the wall where the bathrooms were at, and the only response was continued, to be physically intimidated. I felt in that moment by him. Now, the way he did it had nothing to do with safety and everything to do with control. I have the video. I put it online multiple times. I'm not going to replay it tonight because this can be a long one anyway. But the moment was where something shifted for me, even if I didn't fully understand it yet. This was not about a wallet. It was not about security. It was about authority being exercised in a way that did not tolerate being questioned at all, even in the most reasonable of ways. And that back then I was reasonable as shit. When I walked out of that building, I was not thinking about retaliation or lawsuits or anything like that. I was thinking something much simpler. There really has to be a way to address this, right? Like that this can't be. So I did what I was trained to do. I documented what happened, and I filed a complaint. Followed the process that's supposed to exist for exactly that situation. Because at that point, I still believe the system worked. I believe that if you brought something forward, it would be reviewed honestly and handled appropriately. What I didn't really get or understand at the time is that the moment I documented and reported what happened, the focus was going to shift. It was no longer going to be about the conduct, right? It was going to be no longer about, you know, whether what happened was appropriate. It was going to become about me, Aaron, my name, my actions, my credibility, and how I was going to be handled moving forward. And that's where the story really begins, because everything that follows did not come from confrontation. It came out of me asking a question, documenting the response, and refusing to pretend that what occurred was normal. And it wasn't. Nothing that goes on in this city, in my opinion, is normal. But that's when it stopped being about the incident and started being about me, right? And that was the problem for me, is that it shouldn't have been about me. It should have been about the incident. Now, when I left City Hall that day, I did still believe I was dealing with an isolated incident, right? I believe that if I documented what occurred, what happened, I submitted it through the proper channels, that somebody would look at it and be like, "Oh yeah," objectively they would correct it, but they would be like, "That's not cool. We gotta fix that, right? A simple apology will fix this. We can move on." That belief didn't come out of nowhere. It came from training, from experience, from the assumption that systems built around accountability actually function the way they're supposed to. But I did exactly what any reasonable person would have done. I documented the encounter in detail and I filed a complaint and I followed the process. I didn't go public. I didn't escalate. I didn't try to turn it into something bigger than it was. I gave the system an opportunity to address its own conduct. What I didn't understand at the time is that the moment that the complaint went in, that something else started happening from behind the scenes a little bit, and the focus shifted. Right, it was no longer about what occurred in the lobby. It was no longer about whether an officer's actions were, even justified or not. What it really became down to, not even whether they're appropriate as far as the changing the speed, about whether policy had been followed. The focus became me. That shift is something that I'm not speculating about. It's something that's documented. My name began appearing in internal communications. I've got over 1,273 PDFs were discussions that were no longer centered on resolving an incident. They were centered on how I was being perceived, on how I was engaging, on what was going to be done about it. Right? What was going to be done about Aaron? And at that point, my activity had been limited and clearly protected. I had raised concerns about officer interactions in my neighborhood. I had commented publicly about the Hildreth matter, which was already a topic of grand discussion, managed to make itself viral and still is today. And I had questioned the Lorain Police Department's use of force or use of its Facebook page to restrict public comment. Something that directly touches on the idea of whether a government agency can open a public forum and then control who is allowed to participate in it. You notice that whole social media thing went out the window too with Lorain. But I filed a complaint about what happened inside City Hall, and none of that is outside the law. None of that is harassment. None of that is stalking. That's speech. It's participation. It's exactly what citizens are supposed to be able to do when they are engaging with their government. Unless, of course, you're apparently Aaron Knapp in the city's Lorain. And yet, instead of those concerns being addressed by their merits and on their merits, the response took a little bit of a different direction, right? Like what followed really wasn't a conversation. It was more not even a clarification. It was not even a correction of the conduct that I had reported or been subjected to. It was escalation. Our former Chief McCann didn't respond by resolving the complaint. He responded by initiating contact outside the normal scope of what, that complaint really required. What he did was he reached beyond the department. He reached into my professional life. He sent communications to the Ohio Counselor, Social Worker, and, Marriage and Family Therapist Board. They asked, what did I do to make a chief of police figure out we had a board, let alone how to contact us? But he took what should have been an internal matter, a complaint about conduct in a public building, and inserted it into one place that directly controlled my ability to work. Okay. That's not a neutral act. And for anybody that says it is, that's not a routine follow-up. That's a decision, a conscious decision made to affect someone's life. And the way it was done matters as much as the fact that it was done. The language used in those communications did not describe a citizen raising concerns. It did not describe a professional engaging with government. It described me as unstable, unpredictable, and someone who posed a risk. Words like unhinged were used, which words people still fucking use. You call me that, fuck off. Like, you haven't seen Unhinged, please. I've seen Unhinged in the mental health facilities. Characterizations that were not grounded in any formal finding, not supported by adjudication, and not the result of any due process were presented to a licensing board as if they were established fact. Now, that in itself is illegal. Reporting to a licensing board non-factual information is illegal. Same thing that Tia Hilton did to my CDCA as directed by James McCann. But that's not how a complaint is handled with the goal when the goal is resolution. That's how a narrative is built when the goal is something else. At the same time, communication around me expanded internally immensely. Emails circulated. I have them all. My name is no longer just attached to a complaint, it's attached to discussions about how to proceed, how to respond, what actions might be taken. The issue had already moved beyond the original incident and had become about managing me as a person and a problem in their mind. They weren't going to fix this or solve it. They're fixing or solving it was getting rid of me. And that's where the legal framework begins to matter, because even if you're not thinking about it in legal terms at the time, and I wasn't, the First Amendment protects more than just speech in the abstract. It protects the right to speak on matters of public concern. It protects the right to petition the government to redress grievances. It protects the ability to engage in public discourse without fear of the response from the government will be punitive rather than responsive. And when a citizen, stop. And when a citizen raises concerns, files complaints, or questions government conduct, the appropriate response is to address those concerns, right? Like when the response shifts to targeting the individual citizen, though, who's questioning, by questioning their stability and reaching into their professional licensing, that raises an entirely different set of questions. And those questions aren't theoretical, folks, because what happened next had real consequences. And the problem I have with it is there's not one of you out there that would agree that this is okay if it happened to you. But those questions really lead to what everything happens. Like within a short period of time, the pressure that had been building behind the scenes began to show up in my professional life. My employment was affected. My role within the juvenile justice system was disrupted. I was placed on suspension. I was eventually terminated. And when that termination was reviewed by the Ohio Department of Job and Family Services for unemployment, the determination was clear. I'd been discharged without just cause. It's not my interpretation. That's an official finding by a state board. And at the same time, the licensing complaint that had just been initiated was reviewed by the board. That process is not casual. It involves evaluation of the allegations, review of the facts, consideration of whether a professional was violated ethical or legal standards. And when that process concluded, the result was equally clear. The allegations were not substantiated. The case was closed. Now you have two parallel outcomes. An employment action was found to lack just cause. A licensing complaint was dismissed as unsubstantiated, and those outcomes sit directly next to the actions that triggered them. The contrast is where the pattern starts to become visible, because if the underlying conduct justified the response, you would expect those findings to reflect that. You would expect the licensing board to sustain the complaint. You would expect the employment review to confirm the termination was appropriate. That's not what happened, though. Instead, the actions taken against me were not supported when they were actually reviewed by the formal process. Yet, despite these outcomes, the narrative didn't stop. Everyone still talks shit. The pressure didn't stop. The characterization of me as the problem didn't stop. They started sticking my pictures up on glass windows within the court. James McCann openly admits in messages that he has spoken to multiple judges about me. So which one of you did they speak to? And which one of you have spoken about me? Again, this is why I'm recusing a couple of you right now. Most likely all of you, because all of you jackasses are now tainted, just like the municipal court is. The point where it becomes clear, though, that it's no longer about what happened in the lobby. It's no longer about whether a wallet should have been scanned or whether an officer acted appropriately. It's about something else entirely. It's about how a person who asked questions, documented what he saw, and engaged with his government through lawful channels became the subject of an internal discussions, internal or external complaints, and actions that directly impacted his viability and ability to work. And that's the moment where it stops being a misunderstanding and the moment starts looking like something else. And that's before we read section 3. But we're going to take a quick break, so stay tuned, and we'll be right back, folks.
Here at Unplugged with Aaron Knapp, we like to thank our sponsors. We have a few unofficial sponsors tonight, and they are definitely not paid sponsorships. I want to throw out there a big thank you to Joseph Jones and Eric Jones of the Lorain Daily and the Vermilion Daily. They have a local news page. You should check them out. They do plenty of great work. broadcasting all the news that is the news that you want to have in Lorain and Lorain County. So check them out. Also, please, if you need any legal services, feel free to reach out to Robert Gargas. You can find him listed online. He's a fine attorney and comes highly recommended by yours truly. And last but not least, I want to mention DNC Radio. Please make sure you check out one of the up and coming internet hip hop stations and all of their shows. They put on a lot of shows. You have the Never Outdone show. You also have the Eric Bowen show, Speak Up, Speak Out. So please make sure you guys check them out as well if you're looking for your latest and up-to-date hip-hop artistry. Thank you for tuning in. This has been a non-paid sponsorship brought to you by Unplugged with Aaron.
Sorry about it. That's just my jam, man. The Opus number one, the VA's greatest hit. Any veteran who's ever lived knows that sound. Hell, any veteran that's ever died knows that sound. They're probably listening to it right before they got off by themselves. So, anyway, that brings us to section 3. Welcome back, guys. Thanks for sitting through that a little bit there. We're going to get into section 3 here. Now, by the time everything I described in the last section was unfolding, my name was no longer just tied to a complaint inside the city hall, right? It had started to move into a different space, one that people are quick to use to explain away anything they don't want to deal with. And that's politics, right? I was involved in the 2024 sheriff's race. I'm not going to minimize that. I'm not going to let someone else define it for me. I was not on the payroll. I was not some formal staff member. And I was not operating in anyone's direction, more or less. But I was involved. I had access to campaign information. I was reviewing materials, and I was in communication with Jack Hall at a level that, went beyond casual observation. He had shared information with me, including internal tools, the sign location system that was intended for campaign use, and that's real involvement. I'm not going to pretend otherwise. At the same time, there was a line that matters, and it needs to be understood clearly. I was not coordinating attacks. I was not being directed to target anyone, and I was not acting as an agent of the campaign. What I was doing was exactly what I had already been doing for this with the city, which is I was paying attention, I was asking questions, I was reviewing information, I was speaking on what I saw. The distinction matters because once your name is connected in politics to politics, so to speak, it becomes very easy for people in government to dismiss everything you do as political, regardless of whether it's grounded in fact. A records request becomes an agenda, a complaint becomes an attack, a question becomes something that needs to be managed instead of answered. And that's exactly when things started to shift. At the time, the structure of local government around me was not stable. As you guys know, that instability matters more than people really realize. When all this began, Ray Carrion was my 6th-ward city councilman. He had direct awareness of who I was and what I was doing from the beginning. He was not removed from this. He's part of the environment where these issues were being raised. Then he stepped down, and his seat did not go through a normal contested process at that point. His friend Antonio Baez ended up getting the position. He stepped down at the time of the election, I believe. But, Baez ran in 2023 unopposed, and he secured the seat. But later, about 2 months after he was elected, he accepted a position as a full-time police officer in Sheffield Village, or Lake. I think it was Sheffield Lake. a position that created eligibility issues from holding that council seat. Now, despite that, he continued to hold the seat for all of 2024, even though I was complaining the whole time and had already confirmed it with Sheriff Hall. Now, I think that's where I started slipping off the tracks because Hall wanted to handle it. He said in the guise of some previous sheriff dude, I forget, before Stametti, I don't know, Greg, somebody or another, I don't know. He said, can we do it like something white? I don't know. All I know is that I ended up dropping the bomb early and it pissed everybody off, including him, because they didn't like that I did it the way they did. But Arroyo ended up getting, really what ended up happening was, Baez retires. He claims personal reasons, but it was me harping on the fact that he was a police officer full time, couldn't hold the job. After that resignation, Angel Arroyo was appointed to the position by the Democratic Party. And then in November 2025 election, Arroyo ran and defeated me to retain that seat. He won fair and square. There's no doubt about it. The voters picked him. That's not in question. Never has been. I've never questioned it once. He won fair and square. His name recognition, being a previous councilman, all these things, and the fact that I'm an a-hole probably helped him win the case. He won. That's it. No recount needed. But that entire sequence matters, though, not because it's political commentary, but because it shows how fluid and interconnected the positions around this situation were. The council seat that originally belonged to Carry On did not remain stable. It moved between individuals, appointments, and elections. While at the same time, Carry On himself moved into a different role with more authority. He became the safety service director. Great. But what they wrote and what they left out and what they really used anyway. And at a certain point, I stopped asking how many times my name appeared in the old Chronicle Telegram and started asking a more important question, which is, what exactly did they choose to say each time they used my name? And what did they choose to say at the exact same time those stories were being published? When you actually build that record using identifiable articles and indexed industry entries, you can see what you're seeing. You're not looking at a handful of mentions. You're looking at a minimum of 16 separate times between September of 24 and March of 26 where my name has been mentioned in the Chronicle. That's 16 separate times. How many you can say you've been mentioned in there once and you probably clip the article and put it on your front page, on your fridge? Unless it was like an OBI or something. But that number matters because what happens, or what matters more now is how those 16 items read when you place them next to each other and follow them in sequence. One of the earliest entries tied to my public records activity is framed around the headline, Lorain Council could look to state to limit vexatious record requests. That word is not neutral language. It's simply describing a legal process. It's not simply describing a legal process. It introduces the concept that requests like the ones I'm making could be excessive, burdensome, or even abusive. Now, the preview language reinforces that by referencing requests that harass or annoy, which immediately places the reader in a position where they're evaluating the requester before they have any understanding of what was actually being requested or why the requests were being made. And at that point in time, I was actively pursuing access to records inside a public building, including video footage from the Lorain County Justice System Center. And that's not an abstract issue. That is a question about whether government activity inside a courthouse can be reviewed by the public and whether the denial of the footage is lawful under Ohio public record statutes. But that context doesn't sit next to the word vexatious. What's sitting next to it is the suggestion that the requests themselves may be the problem, right? But when the coverage shifts to the courthouse video dispute, the framing continues in a way that emphasizes conflict over substance. The headline describes a commissioner and a prosecutor who spar over the release of the security video. That word and that word choice, I should say, turns a legal disagreement into something that sounds like a personal or political clash. In the preview, it states that, quote, 4 months, Aaron Knapp has requested video footage, ... inside the Justice Center in Elyria, period. That statement is accurate, but incomplete. What's not presented alongside it is the same framing as why the footage was being requested, why the legal standard or what the legal standard is for withholding it, whether the denial of the footage would have violated or could have violated Ohio law. So the reader is given a persistence without explanation and conflict without legal context. When the story moves into the filing of a court action seeking release of that same video, the language becomes more procedural. It states that, quote, a Lorain man files court action seeking release of video from County Justice Center. And it references that I, quote, requested the video multiple times, end quote, and alleged that the footage would show unlawful detention. That is closer to the actual issue, but it still stops short of explaining the legal framework that governs the request. It does not walk the reader through revised code 149.43 or 149.43G. It does not explain the limits of the so-called security record exemption under 149.433. It doesn't address whether the law requires redaction rather than wholesale denial when sensitive content is claimed. At the same time, there's a separate article where Lorain County pays money to resolve public records and open meetings disputes. The headline of that one reads, the county pays $8,400 to settle 2 legal actions. I'm number 2. And the preview indicates that the story includes comments from me. That is one of the few places where the outcome reflects that these disputes had substance because a settlement involves payment and resolution. But even there, the framing centers the county paying rather than the requester prevailing. It doesn't expand on what the underlying requests were or why the disputes reached that point of monetary resolution. Then the coverage shifts into what becomes a different pattern entirely. When my name appears in connection with an alleged incident, the headline does not use procedural language. It uses impact language. Lorain Council candidate Aaron Knapp in altercation. Places the word candidate directly next to altercation, which immediately ties a political role to a conflict event. That's high impact framing choice because it defines the reader's first impression of what they know anything about the circumstances, context, or the outcome of that incident. The same pattern continues with the protection order coverage with Tia. Amherst Township woman granted protection order against Lorain City Council candidate Aaron Knapp. Centers the granting on the order, right, which is the initial stage of the process. Also ex parte and easy to get. That places my name in the position of the respondent. Follow-up coverage references that a hearing was pursued or pushed and that later that a request for protection order was dismissed without prejudice. That last outcome matters because dismissal without prejudice is not a finding of wrongdoing. But the procedural meaning of that phrase is not explained in the same way. The initial granting of the order is emphasized, right? So what the reader sees clearly is that the order being granted, and then what they are less likely to understand is that it was later dismissed and what that actually means. That's where that pattern becomes difficult to ignore because that language used when I am initiating legal action is procedural and neutral. When the language used when I am the subject of an allegation or restriction is direct and impactful. The pattern continues in 26, where the sequence becomes even more compressed. Lorain man barred from city property following altercation with safety service director. Introduces the concept of a ban, and the word barred carries a strong connotation of exclusion and wrongdoing. The follow-up article states that I appealed the exclusion in court, which returns to procedural language, but still keeps the underlying narrative centered on the ban, right? Then we end up, that's just one. Then we end up, seeing that there is hearing coverage, which reports that a magistrate halted an evidentiary hearing, basically related to the ban as a procedural development, but it still exists within the sequence that's already established a narrative of restriction and conflict. She made statements about my behavior and the way things acted and all these things, and so it was problematic because it went into the record. But hey, there are correction entries. A correction acknowledges that I was in court seeking a temporary restraining order tied to the ban, so they fixed that. There was a correction exists as a separate item, but it doesn't carry the same weight as the original framing. And it doesn't function the same way as a full article does in shaping public perception. Then comes one of the most consequential headlines in the sequence, which states that, and I quote, Lorain man who prevailed over City Hall ban now subject to civil stalking order, end quote. Fuck me, right? That headline places two ideas side by side, that I prevailed in one context and I'm subject to another order in another, but the dominant phrase is subject to a civil stalking order. And I feel like that's one of the most strongest forms of adverse framing that appears through any of their entries. Now, place all that next to something else that's documented. There was a court order that specifically required victim witness permission before certain photographs could be used. That's not speculation. It said it as much. That's a condition imposed by the court. Despite that requirement, those same photographs that were taken by the Chronicle have been used not once, not twice, but 3 times now in articles that they wrote about me. Now, I never gave them permission to use those photos. In fact, I specifically told their photographer not to. And since there's an order that says you're not supposed to do that, I wonder what the court's going to do about that to the Chronicle. But hey, when they do it, no problem, right? When I try to do something, it's always a problem. I got you. But that was a condition imposed by the court, not by me or anyone else. And despite that requirement, they used the photograph. So, the Chronicle gets to do what they want, I guess. Just violate a court order, right? Who cares? I mean, I guess I can now. But that raises a question about compliance with the order, about whether permission was obtained, how those materials are being presented publicly. And yet the issue is not explored in the same way the underlying allegations are. So when you step back and you look at the entire record, the number of articles, the language used in the headlines, the difference between procedural framing and the impact framing, the emphasis on initial allegations versus limited explanation of later outcomes, and the use of materials that were subject to a court condition, which is don't take the witness pictures without permission. What emerges is not a single article that can be labeled one way or the other. What emerges is a pattern by the Chronicle, a pattern where my name is repeatedly introduced in connection with conflict, restriction, and allegation. While the legal work I was doing, the statutory arguments I was making, the outcomes I achieved, and the conditions imposed by the court are either minimized, separated, or not explained in the same clarity. I always love that. You can always tell someone I wrote because I include that in there because my daughter's name Clarity. That pattern doesn't require interpretation. It's visible in the words themselves. Brings us to part 6, the ban, the courts, the warrant, and the traffic stop. And we're going to take a quick break right there before we get back to our next section. In the meantime, I'm going to leave this slide up for a minute for you guys to take a look at it. This is an entry that I responded to the judge with. We'll just pop it up there for you guys to read. Yeah, well, there's a lot there, and you guys can check out that document on my page if you want to see it. There's 9, 10, yeah, like there's a lot of pages on there. This was my response to the court. You can see it on my page. I'm not gonna sit here and make everybody sit through all that. I just had that as a filler spot in between the break. So let's get back to what we're on section 6 here. So to understand what happened on the roadside when I got pulled over recently, which if you've been listening to my other podcast, you know you can't isolate it from what came before because by those times the officers approached my vehicle. The structure had already been built through a series of escalating actions that began inside City Hall and moved through the courts and extended into law enforcement coordination, which was not, you know, and not really being disclosed, right? What occurred March 19th was not a routine traffic stop. It was not an isolated enforcement decision. It was the execution phase of a process that had already been set in motion. Every step of that process has to be examined together if you're going to understand what actually happened. The starting point is the ban from City Hall, because that's where the question of public access and was turned into a restriction on a citizen's ability to engage with the government. Now, the ban was not narrow, it was not temporary, and it was not tied to a clearly defined conditions that could be evaluated or challenged in any meaningful way. It was broad, categorical, removing me from public buildings where government business is conducted and where citizens are expected to be able to go and observe, participate, and hold government accountable. When a government imposes that kind of a restriction, it's not simply managing a building, it's restricting access to public forums. That implicates constitutional protections tied to speech, participation, and due process. Now, when that issue reached the court, the response was not to affirm the ban as an issue. The issue was not just whether something had occurred inside the city hall. The issue was whether the mechanism being used to enforce that restriction complied with the law, and it did. And the signal from the court was that if the city intended to impose a restriction of that magnitude, it needed to do so through a legally recognized process. Well, the city didn't withdraw the restriction; it escalated. What began as an administrative ban became a civil protection order. Right. First, we fought in the regular court. I won there, but that matter's still pending for I won the temporary restraining order, but everyone forgets I still had the injunction in place, which there's no reason I shouldn't win the injunction if I won the TRO, because if it was unconstitutional then, it's unconstitutional now. But then Ray goes down, I should say, not the city, and gets this civil protection order based on the words of the judge in the case where Ray wasn't at, where his attorney apparently was, Mr. Levesque, who's also mattered to all these matters. But at the same time, I filed my own action seeking relief. The court granted temporary relief in my favor. It demonstrates the legality of the original ban was not one-sided and was still in dispute. That's so important. Instead of allowing that matter to be resolved within a single forum, a second track was opened by Mr. Carrion when he filed that civil protection order at the behest of the judge in the current case, or I should say the magistrate. So another court now is involved. They issue a protection order, based on the same underlying facts, creating overlapping proceedings that relied on the same narrative, because they used the narrative and the transcripts from this trial, the first trial, to get the second one. And that's where the process begins to break down, because I was found ultimately to have prevailed in the first one. And so a judge wouldn't have normally sided that way. But since they took impartially without a decision to the other judge, well, yeah, this judge says all these bad things about him, we'll definitely give it either protection order, right? You don't even need to ask. That's the problem, because now it's being used in different courts without a unified determination, and the outcome begins to one and reinforces the next. From there, the escalation moved into a realm of search and seizure, and the allegation became that I violated this protection order somehow electronically, and that allegation was used to justify a search warrant. And at that point, the Fourth Amendment to the United States Constitution, Article 1, Section 14 of the Ohio Constitution, they're not theoretical protections. They are the governing law that defines what can and cannot be done. A warrant must be supported by probable cause. It wasn't. Must establish a clear nexus between the alleged offense and the items to be seized. It didn't. And must be particularized so that it does not authorize a general search. It definitely didn't. The warrant in this case authorized the seizure of personal cellular phones, without limiting language tied to a time frame, specific communications identified to individuals or scope of data. That type of breadth is not incidental. A modern cell phone contains extensive personal information without a limitation. A warrant targeting the device rather than defined evidence raises a serious concerns under overbreadth and lack of particularity. The judge should have known that, but apparently Rothgary doesn't understand the law. I mean, it's not like it's required of him, right, to know the law. When you're a judge, you get the lawyers to tell you the law. So I guess the lawyers that brought the case are the fucking idiots that don't know the law. But somewhere in here, somebody's the fucking idiot that doesn't know the law. And it fucking isn't me. How dare some jackass judge like Rothgary go and fucking write this order without any factual basis? You don't connect it. You don't add the fucking, you don't add the affidavit, the one piece you needed to add to make it legal. Man, you guys are a train wreck in Lorain County. I'm not even a lawyer and I can figure that shit out. And you were the only judge willing to take it. And you're the judge that's on my civil case and should have known better. Democratic mouthpiece is right. This is why you guys got to pay attention to who you elect as judges too, folks. They're just lawyers. If they'd have looked at the case law, they'd have known what they were doing was bullshit. Riley v. California says it. And there's multiple other ones that we're going to discuss that go down saying it. How do you, as an attorney, as a judge, and as a legal professional, not know this shit, but I do? But hey, whatever. I guess you just don't need to know the law in Lorain, right? You just make it up as you go along. But hey, they went ahead and issued and executed a warrant as a traffic stop when my daughter was in the car that began as a minor lane change violation. That fact matters because the law places strict limits on what can occur during a stop of that nature, right? A traffic stop is limited to addressing the violation that justified it, period. It allows for identification, which I gave my ID, verification of documentation, which they never asked for, and the issuance of a citation or a warning, which they never gave. Once the purpose is completed, the stop must end unless there's an independent reason for suspicion of additional criminal activity. The United States Supreme Court made that explicit in Rodriguez v. U.S. And that rule is not flexible. It doesn't bend. It's a hard limitation on how long a person can be detained for a minor traffic infraction, period. Oops. Somebody fucked up. The limitation was not allowed here, right? It wasn't followed. I mean, no ticket was issued ever. No warning was issued ever. The purpose of the stop was never completed. Instead, the detention continued for approximately 20 minutes, during which I was not free to leave, and I was the focus of the interaction, shifted entirely away from the lane change violation. No more questions were asked about that ever. I was removed from the vehicle for officer safety in front of my child. That detail is not incidental because it defines the environment in which every decision was made. This was a roadside detention involving a parent and a minor. The officers on scene were fully well aware of that as the situation escalated. After being removed, I was subjected to a pat-down search. Under Terry v. Ohio, that type of search is limited to a protective frisk for weapons and requires specific, articulable facts that would lead an officer to reasonably believe that a person is armed and dangerous. There were no such facts here. No such indicated that I posed any threat, and what happens next confirms that purpose of the search was not officer safety. The interaction did not end when a weapon wasn't found. It shifted directly to a targeting of a specific item. He grabbed my phone. The phone is not a weapon, doesn't justify a Terry frisk, and at the moment, the search transactions from a protective measure into a seizure of a specific piece of property unrelated to officer safety, the legal justification changes entirely. That means you fucked up. That's where this stops being, anything normal. The stop itself becomes pretextual. They stop me for the warrant. That's a problem for them. The traffic violation is no longer the purpose of the stop. It becomes the entry point for a different objective, the seizure of a device that officers were already seeking to obtain, and they were well aware of that. The extension of the stop, the removal from the vehicle, the search, all moved towards that outcome. Even though none of those steps are tied to the original violation, that's exactly what constitutional limits are designed to prevent. Because without those limits, any minor traffic infraction can be used as a gateway to conduct searches and seizures that would otherwise require independent justification. The execution of the warrant itself raises further issues. The phone was taken before the warrant was meaningfully presented. I never got the warrant until the very end. I asked to see it, and an officer displayed paperwork like, dude, and then closed it. Like Bradley with his. He refused to let me read it. He didn't read it, stating concern that I might destroy it. Now, that compared to the officer the previous day tried to read me a fucking, restraining order verbatim. I wouldn't leave until he did. But that doesn't satisfy the requirement that a warrant serves as a visible legal authority. A warrant is not a formality. It is the legal justification for the seizure, and it must be presented in a way that allows the person whose property is being taken to understand what is being authorized. The warrant referenced a supporting affidavit, yet the affidavit was not provided. No 5 pages. The seizure occurred first, and the justification was asserted later, reversing the order required by law. You guys broke the law again. Fucking Lorain cops can't even follow the fucking law. The situation escalated further during the encounter. I was threatened with arrest for obstruction based on how I was communicating. Because apparently you can't do this. This was in my face. No, it wasn't, you fucking pussy. It wasn't in your face. And why don't you try to fucking clean your bitch asses up? Don't wear hoodies. Don't wear Converse All-Stars. Shave your face. Maybe get some fake teeth like me. One of you. You guys look like a train wreck on the side of the road. You fucking undercovers, more like homeless. Like we hired the homeless to be cops. But whatever, right? You just dress and do however you want. Be damned the manual that tells you how to dress. The situation escalated further during the encounter. Like I said, I was threatened with arrest based on obstruction. Using my hands while speaking. That's not resistance. That's not interference. That's communication under stress. I requested accommodations related to PTSD. That request was ignored. At that point, the issue is no longer about whether the warrant exists on paper. It's about how the authority is being exercised in practice and whether that authority is being used in a way that respects legal limits or in a way that compels compliance with us through escalation. Now, at the same time, there's another layer that can't be ignored. Based on recent emails, there were communications between the city and the chief of Amherst relating to a matter involving me. The city has taken the position that those records are confidential law enforcement investigatory records. That designation is not self-proving. Under Ohio law, an entire record cannot be withheld simply because it relates to an investigation. The agency must show that the release would create a high probability of harm to an ongoing investigation or reveal specific protected elements. When communications exist between agencies regarding a known individual who is actively engaged in litigation and public reporting, and those communications are later withheld in their entirety, the question is not simply whether an exemption was claimed. The question is whether the exemption is being used to shield coordination rather than to protect a legitimate investigatory interest. That matters because those records exist within the same timeline as the ban, the protection orders, the warrant. They all reflect communication between agencies, and this is about the same individual who's being subjected to those actions. And in one case, I'm my own attorney. I have a right to those documents. If the communications influence decisions that led to the issuance of the warrant or the execution of the stop, then they're directly relevant to understanding how those actions occurred. When they are withheld, it prevents review of whether or not those decisions were made independently or as part of a broader pattern of coordination. When all of this is viewed together as a single continuous sequence, the ban from a public building, the shift from a civic protection order, and the existence of parallel court proceedings, the allegation of a violation, the issuance of a warrant lacking clear limitation, the absence of the supporting affidavit, the execution of the warrant through a prolonged traffic stop that never resulted in any citations being issued, and the targeted seizure of a phone in front of a child and the existence of interagency communications being withheld under a classification that requires scrutiny is no longer possible. To treat any part of this as isolated. It's a chain of actions. Each step builds on the last. And it's exactly what I knew you guys were going to do. Thank you, by the way, for proving me right every single time. I told Garen all this was going to happen, and it did. Now you make me look like a black magic voodoo lady. Each action narrows the space around me. Each decision relies on the one before it. And when the chain is examined as a whole, it happens. What happened on that roadside doesn't just read as a routine stop that escalates unexpectedly. It reads as the execution of a process that had already been set in motion, where the authority of a traffic stop was used to carry out seizure that was not connected to the violation that was justified the stop in the first place. And that's where the constitutional issue becomes unavoidable. Again, you guys are just a constitutional train wreck. because the Constitution does not regulate what is written in the warrant. It regulates how the warrant is executed, how long a person can be detained, what searches are conducted, and whether the power of the state is being used within the limits that are required to respect, right? And there's a point when this case stops being about interpretation and starts being about the documented coordination. That point is reached the moment a sitting prosecutor acknowledges that conversations took place about me within the judicial system, while at the same time the record already shows those conversations occurring outside any formal proceeding. What was conveyed to my counsel by Tony Sillo, the prosecutor, was not a vague. It was not framed as speculation. It was described as not a county matter, what was going on right now. That judges had recused themselves because they did not want to deal with me based on my reporting in Lorain Municipal Court, and that there had been a discussion. There had been discussions. That statement standing alone would already raise concern, but it does not stand alone. It sits on top of the documented history of communication between law enforcement, court administration, and external bodies that show these discussions were already happening before any formal judicial action was ever taken. And the most critical question that flows from the statement is not rhetorical, and it's not something that can be brushed aside. Which judges were involved in those discussions with Chief McCann that he mentions in his emails, that he's spoken to multiple judges? And in what capacity were they speaking about a private citizen outside any formal case proceeding? Because once it's acknowledged that multiple judges were consulted in McCann's case, even in general terms, the integrity of any subsequent recusal, assignment, or warrant becomes inseparable from those prior communications. The problem is not simply the judges may have recused themselves. Judges recuse themselves all the time for valid reasons. The problem is that the reason given was not a disclosed conflict of interest, not a financial interest, not a familial relationship, but exposure to reporting and prior discussion about the individual involved. That's not a neutral basis for recusal. And more importantly, it raises the question of whether opinions were being formed and shared before any case ever properly hit the court. The question becomes even more serious when you place it next to the documented statements from former Chief McCann, who explicitly stated that he had spoken with multiple common plea judges about me. That communication did not occur in a courtroom, did not occur in a record. It did not occur in the presence of counsel. It occurred informally in connection with complaints I had filed and advocacy I was engaged in. That means at least some members of the judiciary were exposed to a narrative about me that was being shaped by law enforcement before any legal process was initiated. When you later hear that judges recused themselves because they did not want to deal with you, that question is no longer whether a recusal occurred. The question is whether the recusal was influenced by prior off-the-record communication. This should have never happened in the first place. The issue does not exist in isolation, and it does not stop the conversation. There is an active federal lawsuit pending that names multiple individuals connected to the same system, including law enforcement, leadership, court administration, and municipal officials. That means the judiciary is not simply aware that I'm a litigant. They're aware that I'm a party actively challenging conduct within the same governmental structure that they're a part of. When that reality is combined with the acknowledged discussions about me, it creates a situation where impartiality is not a legal requirement, but a factual question. Because if judges have been exposed to off-the-record narratives from anyone, especially the prosecuting attorney, Tony Sillo, who's rambling on to my attorney about it. Oh, well, there's been discussions. Well, if there's been discussions, then you need to fucking recuse yourself, you podunk ass dummy. Because if judges have been exposed to off-the-record narratives, then they've discussed me in a form outside those formal proceedings, just like, Bremke is always showing up as a possible friend suggestion. Then maybe every subsequent action taken in any one of my cases has to be viewed through that lens. That's where the pattern becomes unavoidable, because the same system that engaged in those discussions now is engaged in actions that directly affect my employment, my professional standing, and my legal position. Communications from court administration show that concerns were raised about me. Those concerns were acted upon in a way that resulted in removal from my role. At the same time, law enforcement was contacting licensing authorities, questioning my fitness, and initiating external scrutiny. Hey, those are not parallel events happening independently, folks. You can't see that, I don't know what the fuck to tell you. They're sequential actions that align with one another, and they're all stemming from the same underlying fact that I was actively reporting on and challenging government conduct. The refusal to disclose additional communications and their claims of confidential investigatory records only deepens the issue because it prevents any clear understanding of the full scope of those discussions. What's being withheld is not some abstract investigation technique, it's communication between public officials about a known individual in a context of actions that have already occurred. When those communications are withheld while their effects are visible, the public is left with the outcomes but no explanation of how those outcomes were reached. That's the exact opposite of transparency, and it becomes especially problematic when our chief, Mr. Fouling, is the one doing it, and when the communications in question may involve members of the judiciary who are also maybe possibly closely connected to it, and others. The question of which judges was involved is not about naming individuals for the sake of speculation. It's about understanding whether the judicial process itself has been influenced by information that was never subjected to adversarial testing. If a judge recuses because of exposure to reporting, that's one issue. If a judge recuses because they were part of discussions about an individual, before the case was filed, well, that's something entirely different. And if after those recusals a warrant is still issued by a judge connected to the same system, in a case involving the same individuals, based on the same facts that are intertwined with the prior discussions, then the integrity of the warrant cannot be separated from the process that led to it. And when you take all of that together, you get an unlawful bunch of pigs. The statement that there has been discussion is no longer a minor detail. When Tony Silva mentioned that to my lawyer, that there's been discussion because he wants to know how everybody knows, well, it's the center of the issue, fuckers. It's the point where the line between independent decision making and coordination begin to blur. And that's when you have to get special prosecutors in and outside everything. Because once discussion is acknowledged, once the record shows that discussion included law enforcement, court administration, and potentially members of the judiciary, the question becomes whether the system was functioning as a set of independent actors or as a network. Our friends in law enforcement, they're not your friends. They're not your partners. You almost need to see each other as adversaries in bequest of the citizenry. The answer to that question matters because the Constitution doesn't just protect their outcomes. It protects process. It protects and requires the decisions be made on evidence presented in court, not narratives shared outside it. It requires that warrants be issued based on neutral evaluation, not prior exposure to untested claims, and it requires that individuals be judged based on facts, not reputations, formed through internal discussion. If those principles are compromised, even indirectly, then every action that follows must be examined for not just what it did, but for how it came to be. And that's why that question remains open and why we can't ignore it. Which judges were part of the discussions? Which judges did you talk to, Tony? Which judges did McCann talk to? How many of them received emails about me? How many of them saw that paper on the glass wall of the clerk's office with my photograph? Because until that's answered, the record's incomplete, and the integrity of every fucking decision you made within that system will still remain in question. That's going to bring us to Section 8, who I am to them, and from city emails to the front page and mentions and what that costs. We're going to take another quick break, and then we'll return.
Hey there, folks. Aaron here at Unplugged with Aaron Knapp. I want to give you a quick reminder for everyone watching that the city of Lorain holds its regular city council meetings on the first and third Monday of every month. And those meetings are not just for council members. They are for residents. If you care about what happens in your city, and if you speak or want to speak on an issue, ask a question, or simply be present and informed, showing up matters. Participation matters. Even sitting in the room and listening matters. You do not need to be an expert on any of this. You do not need permission to care. You do not need to do anything other than just show up. So check the agenda, folks. Mark your calendar. And if something affects your neighborhood, your family, or your future, take a seat, raise your hand, and make your voice part of the record. Lorain City Council, first and third Monday. Your city, your meetings. Those council meetings start at 6 p.m. Eastern Standard Time, and they're held inside of City Hall. Make sure you attend this Monday's meeting.
All right, folks, that brings us back to section 8. God, I hope we're getting to the end. I'm tired. Who I am. When you start with the city of Lorain alone, before you even move outward into the county, the courts, anything else, the record already tells you something that's fundamentally different about how I'm being treated, because the emails do not reflect a single interaction, a single complaint, or a one-time issue that passed through the system and then disappeared. What they show is sustained attention over time, where my name appears again and again and again and again and again across multiple threads. So many that it becomes hard for them to pull them. Multiple officials, multiple decisions. That kind of repetition doesn't happen in normal government operations involving a private citizen. It just doesn't. When you actually read those emails in full without breaking them into fragments, you see my name shows up dozens of times. And even when you remove repeated reply chains, oh, I can't take that call. I have to wait for that to finish. I can't right now, Amber. I will call you back. I promise. All right. Sorry about that. Um, yeah, I've sustained attention over time where my name appears time and time again. And that doesn't happen. Like, I'm the subject of being, discussed. You're left feeling roughly 15 to 20 separate references where the city officials are talking about me, evaluating me, reacting to me in a way that goes beyond routine interaction and into something that reflects continuity, awareness, and ongoing attention. The pattern inside the city does not exist in isolation. Hold on. Hey, I'm in the middle of a podcast. I'll call you right back. You are right now? Yeah. Okay? All right. Sorry about that, folks. Duty calls. Um, Now, that brings us to the Chronicle, because my name appears in at least 16 separate mentions of the Chronicle in roughly the same time frame. And if you're looking no longer at two unrelated sets of information, what you're seeing is internal discussion and external narrative moving in parallel, reinforcing each other in a way that can't be dismissed as coincidence. Inside the city, my name is being circulated across the departments and roles, and I'm no longer just a person making requests, but the person being discussed as an issue. I'm actually the subject of the requests. Um, and outside the city, my name is being presented to the public through a series of articles that consistently frame me through conflict, enforcement, legal proceedings, and restriction rather than walk through the work that led to those conflicts in the first place. When you put these two things together, the significance is not just in the numbers. The significance is itself is, but it's how the numbers align, because the internal record shows how often I'm being talked about within the government, while the external record shows how often I'm being shown to the public. And both follow a pattern that's consistent over time. The consistency is what matters, because it means this is not reactive or occasional attention, but sustained and structured attention, where the same name is being repeated internally and externally in ways that shape perception on both sides. Inside the system, the reputation creates familiarity and shared understanding among officials. And outside the system, the reputation creates a public narrative that becomes increasingly difficult to separate from the individual being described, right? Everyone wants to shit on Aaron. Well, the sustained attention is not abstract and it's not without consequence, because it does not stay confined to emails and articles or internal discussions. It carries real into real life, into employment, professional standing, and the ability to continue working in a field I was trained for. Over the course of these years, while the pattern was unfolding for the city across the county, across multiple the public record, the pressure didn't remain theoretical. It became cumulative. And that cumulative pressure ultimately forced me out of my profession. I went from competing or completing my education, from working in my field, from actively building a career to being pushed back onto disability, and this time not temporarily, not as a setback, but permanently. That's not a small consequence. And it's not something that can be separated from the pattern that led up to it. Because when a person's name is repeatedly circulated within the government as a subject of concern, when the same name is repeatedly presented to the public through conflict based coverage, and when that reputation continues across administrations, across departments, and across roles, the impact does not stop at perception. It affects opportunities, it affects credibility, it affects the ability to function professionally within the same system that is generating that narrative. And that's the part that doesn't show up in a single email or a single article. But it's the part that matters most because it's the real world outcome of sustained, legal, aligned attention that never resets and never goes away. Oh, dehydration. Well, that's why this can't be dismissed as coincidence or routine government interaction, because the record shows repetition, the narrative shows reinforcement, the outcomes show impact. Oh, wait, hold on. I gotta do this in the middle of my video for somebody. Yeah, I'm a tired fool, man. I'm old. Sometimes I fall asleep in the middle of shit. But when all three things exist together, internal discussion, external presentation, tangible consequences, and you're looking at is not just visibility, you're looking at a pattern that follows a person across time and across systems. And in this case, that pattern did not just define how I was seen, it defined how I was ultimately able to continue doing what I was forced to leave behind. Now, I've endured, what I've endured, and this is not about them, it's about what they represent. None of this can be understood if reduced to personalities, and that's exactly what keeps happening because the moment it's framed as a personal dispute, the entire foundation of what I've been doing gets stripped away and replaced with something easier to dismiss. I've requested that charges be brought against public officials based on documented conduct. I have spoken directly and at times forcefully, and yes, I've used language that includes profanity when confronting them. But none of that removes the constitutional protections that apply to speech directed at government actors. The First Amendment does not exist to protect polite disagreements alone. It exists to protect criticism that is sharp, uncomfortable, and disruptive, especially when that criticism is aimed at those who hold authority over the public. What has been attempted here is a reframing where the focus is shifted away from the substance of what I've reported and onto how I've said it. Because once the focus becomes tone, the underlying conduct can be ignored, right? This has never been about them as individuals. I don't give two shits about them as individuals, and that's critical to make that distinction clear because it changes how everything else is interpreted. I'm not interacting with private citizens in these situations. I'm interacting with officials who have been given authority by the public, and that authority comes with obligations that's not optional. When I write about them, when I speak to them, when I write and I file against them, when I request records, when I call for accountability, I'm engaging with the roles they occupy, not the personalities behind the roles. As individuals, they do not matter in that context of that discussion. But as officials, they're the ones responsible for upholding the law, for respecting constitutional limits, and for ensuring that the system functions as it's supposed to. This is why they matter, because they represent the point where government power is exercised, and they also cannot be separated from the broader context of what has occurred over time. Because I have not been a passive observer or someone casually interacting with the government. I've written stories about them. I've accused them of misconduct. I've challenged their actions publicly. I've taken legal action against them. I've been involved in matters that contributed to the removal of a police chief. I have engaged in issues involving council representation. I've directly confronted the structure of how decisions are being made at both the city and the county level. That kind of involvement does not exist without consequence. And it doesn't happen in a vacuum because it places me directly in the opposition of individuals and institutions that have the ability to respond. When you place that context next to everything else, the repeated mentions in emails, the repeated presence in the media at the chronicle level, the enforcement actions, the legal cases, the continued escalation, the pattern begins to take a different meaning, right? It's not just a series of unrelated events, and it's not just a collection of individual disputes. It's sustained interaction between a citizen engaging in protected activity and a system that is repeatedly responding to that activity across multiple channels. And this is where the question of retaliation becomes unavoidable. Because retaliation is not defined by one act or a decision, it's defined by a pattern that emerges over time. When actions are taken in response to protected conduct in a way that increases pressure rather than resolves the issue. This is where you start to see what feels like a setup, right? What I've endured cannot be measured by a single incident because it's the accumulation that defines it. It is the repeated steps and stops, the repeated references, the repeated legal actions, and the repeated public exposure that together create a situation that goes beyond any one event would suggest. There are allegations of assault that remain unaddressed. There are constitutional violations that have not been meaningfully examined. There is a continued cycle where each step forward is met with additional action rather than resolution. And that's not how a system is supposed to function when it's working correctly, because the purpose of process is to address the claims, not multiply them. And at the same time, there has to be understood in the terms of its impact, because it's not remained confined to documents or court filings. This sustained attention has affected my professional life. It's forced me out of my field, placed me back on disability permanently as a veteran, messed with my kid, and that's not a minor consequence. And it's not something that can be separated from the pattern that led to it, because when an individual is repeatedly subjected to this level of attention across government and media, the effects extend far beyond any single case or single outcome. That's why framing matters, folks, because they want this to be about them. They want it to be how they were spoken to, about how they were criticized, and about how they were challenged. But the framing misses the entire point. This isn't about them as individuals. This is about the relationship between a citizen and their government, and whether the citizen can engage in reporting and litigation and in criticism without becoming the subject of sustained and escalating response across the very system that they are challenging. It's about whether the rights that exist on paper actually function in practice, and whether they're being exercised at this level. And that's where the line has to be drawn clearly, because the individuals do not matter in this context, but as officials, they represent the highest level of responsibility within the system. They are the ones who decide how power is used. They are the ones who determine how the law is applied, and they are the ones who uphold and or undermine the protections that were supposed to exist for everyone. When those responsibilities are not met, those obligations are not honored, and when the response to accountability is escalation rather than correction, the issue is no longer personal. It's systematic. And that's exactly what this has been from the very beginning. When you look at it from a distance, you take all the individual pieces and place them next to each other. Instead of treating them as separate events, the question really is naturally follows it is whether something has happened, but how many times it has happened before, and how many times it's allowed to happen before it's recognized for what it is. And there's a point when repeated investigation, repeated attempts to change or charge, repeated escalation, and repeated scrutiny of the same individual stop looking like routine enforcement and start looking like something else entirely. That point is not defined by a single number written into a statute, but defined by a pattern of frequency and the absence of outcome despite continued effort. In any functioning system, an investigation is supposed to resolve something. It's supposed to determine whether there's evidence, whether there's a basis for action, and whether the further steps are warranted. If evidence exists, charges follow. If evidence does not exist, the matter closes. That's how it's supposed to work. What's not supposed to happen is the same individual being repeatedly investigated, repeatedly scrutinized, and repeatedly subjected to new allegations that do not result in sustained findings, while the process itself continues without interruption. At that point, the function of the investigation begins to shift, and it no longer is producing resolution, it's producing repetition. And that is where the question of targeting becomes unavoidable, because targeting is not defined by a single act or a single decision. It's defined by a pattern of conduct directed at a specific individual that continues despite the absence of substantiated outcomes. When the same name appears again, and again in investigations and complaints and internal discussions, and in enforcement actions. And when those actions do not result in findings that justify their continuation, the focus moves away from what is being investigated and towards who is being investigated. And that is the point where the individual becomes the subject, not because of evidence, not because of attention. But because of attention, right? The attention they're getting from that government official. The law does not require a person to endure an unlimited number of investigations before recognizing that pattern. And it does not require that each investigation be viewed in isolation when the same actors, the same agencies, and the same individuals are involved repeatedly over time. Courts have long since recognized that patterns of conduct, when viewed collectively, can establish a different legal reality than any single act viewed on its own. That principle applies here because the issue is not whether only one investigation can be justified in isolation, but whether the accumulation of those investigations, the frequency with which they occurred, and the lack of sustained findings create a pattern that serves a different purpose than enforcement. That purpose becomes clearer when you consider the effect, because repeated investigation does not exist in a vacuum. It consumes time, it creates legal exposure, it imposes stress, and it forces the individual involved to continually respond, defend, and engage with a process that never seems to reach a real conclusion. That effect is not incidental. That is the result of repetition without resolution. And that is exactly what transforms a series of actions into a pattern of conduct that is easily described as harassment. The question becomes not, then not how many times is enough. When there's no fixed number written into the law, the answer is found in the pattern itself. When investigations continue without findings, when charges are pursued and fail to materialize anything, when new allegations arise without new evidence, and then the same individual remains the focus of that cycle, the pattern speaks for itself. It demonstrates that the process is no longer functioning as a tool for determining facts, but as a mechanism that continues to operate regardless of those facts show. And that's why it can't be dismissed as coincidence or routine procedure, because the routine procedure proceeds with results. It produces charges with evidence exists and closure when it doesn't. What we have here is something different because the process continues even when it doesn't produce those results. And it continues to focus on the same person despite that absence. That's the point where the question is no longer about each action can be justified independently, but whether the pattern as a whole reflects something that the law isn't designed to allow. That's the point where it has a name, because the conduct is repeated, distracted, and sustained against a specific individual in a way that imposes burden without producing resolution. It's no longer an investigation. It's no longer just enforcement. It becomes something that must be evaluated for what it is in its entirety, not in its pieces. And when viewed that way, the pattern becomes clear enough that it's no longer speculation to understand. It becomes retaliatory. Things have been said recently about, racism, words used as a weapon. When you step back and look at actually what's said about me, both publicly and within the system, the pattern is not limited to investigations or legal actions. It extends into how I've been described, how I've been labeled, how those labels have been allowed to circulate without correction at all. I've been cursed at and then called names that are not just insulting but deliberately dehumanizing. I've been subjected to racial epithets that don't even apply to me. I've been accused of a range of deviant behaviors that have no basis in fact. Those statements have not just come from one place. They have not been confined to private conversations. They've come from all over. Members of the public, ordained ministers, in chat rooms, members of school boards, in chairs. They all think they can say what they want without any repercussion. Sure, they get mad when I say something, but they can just run their mouths whenever they want without any repercussion, right? It's fine. Oh, I think I heard you say something to somebody in a parking lot once, and I saw it with my own eyes. Fuck off. Everyone's mean to me. Fuck off. The broader narrative that surrounds me, everyone's fucking mean to me. What matters is not just that those statements were made, but that they were allowed to stand. Repeated, and in some instances and cases reinforced by the same system that's supposed to operate on facts, evidence, and law. And when someone is labeled repeatedly as a liar when accusations are made without substantiation, and when those accusations are not corrected or addressed, they take on a life of their own. They become part of how that person's perceived, regardless of whether they are true or not, and that perception is established, and it becomes easy for every subsequent action to be viewed through that lens. And that's where the problem becomes systematic. Dramatic. Why is Grease lightning? Because the law is supposed to operate independently of that kind of narrative. Grease lightning, go, grease lightning. It's supposed to rely on evidence, not reputation. Grease lightning, go, grease lightning. And it's supposed to be a simple fact that allegation before taking action. Anyway, a separate fact before taking allegation. When the same individual is subjected to the repeated accusations, repeated labeling, repeated public characterizations that's not grounded in public fact or proven fact, and when that occurs along repeated investigation by officials and enforcement, the question is whether those narratives are influencing how decisions are being made. Because once again, I'm stuck in the middle of some bullshit and they stole my fucking phone. What? Because somebody told you that somebody sent a message to somebody and it might have been me, and you think you can just take my phone with a generalized warrant, violate every fucking constitutional statute known to man, and just say, fuck it, we don't care, we do what we want, Lorain? The record does not show that I have been found to be engaged in conduct that I have been accused of. And that matters because accusations alone don't establish wrongdoing. What it does show is that those accusations have been allowed to circulate, to be repeated, and to be embedded into how I'm discussed, how I'm perceived. Creates a situation where the individual is not just responding to legal actions, but to a narrative that exists alongside actions and in some cases precedes them. You can even give me a fair trial in Lorain right now. Good luck finding someone who doesn't know me or my face. I mean, y'all posted it all over the courthouse. At the same time, the absence of a correction or accountability in those statements raises another question, because if the system is willing to act on allegations made against an individual, it should be willing to address the allegations made that the individual that are false or unsupported. When that does not happen, when one side of the equation results in actions and others in silence, the imbalance becomes the issue itself. It's not about sensitivity or personal offense, folks. It's about how information is treated. It's about how accusations are handled and how the absence of a response in one direction affects the overall process. But when words are used in that way repeatedly and without consequence, they do not remain isolated statements. They become part of the environment in which the decisions are made, part of the lore of the individual, so to speak. And that environment really matters because it shapes how everything else gets interpreted, right? And the record reflects what the record reflects is not just a series of statements, folks. It's a pattern in which those statements exist alongside legal and administrative actions directed at the same individual, yours truly. And that combination is what has to be examined, because the law is not supposed to operate where a narrative that has not been tested, and is not supposed to allow the narrative to stand unchallenged when it is not supported by evidence. You know, the ex-chief called me unhinged and crazy long before any other officials chimed in, and now many of them repeated it long after he's gone. And then you think about what's been said and how it's spread, and that label just doesn't go away. You know, former Chief McCann described me as unhinged and suggested that I was not stable long before other officials used the language. Once that kind of label is introduced, it doesn't sit there, it moves, it gets repeated, it gets referenced indirectly, it gets absorbed into the common thought process and how others speak and write. That narrative works inside institutions because when a person in authority defines someone in a certain way, that definition becomes a starting point for others who interact with the same individual. It becomes easier to adopt the characterization rather than question it, because especially when the person who introduced it holds a position that carries weight and influence like chief. What makes it more significant is that the language didn't just disappear when McCann was no longer in that position. It continued. Other officials have been using similar terms, similar descriptions, similar framing long after he's been gone, including our current chief, apparently, which shows that the label is already taken hold. It was no longer tied to the individual's opinion, and McCann, it's taken part of the whole institutional understanding of Aaron. And that's where the point where it stops being a statement and starts being a narrative. The narrative then interacts with everything else that's happening, because when someone is repeatedly described as unstable, as unreasonable, or as and not credible, those descriptions do not exist in isolation from actions being taken against them. They influence how complaints are received, how reports are interpreted, how decisions are made. When I report an issue, when I file a complaint, when I raise a concern, that narrative sits in the background, shaping how all those actions are viewed before they're ever evaluated on their merits. This is why the origin of the language matters, because it wasn't developed organically over time based on proven conduct. It was introduced early before many of the later events even occurred. And it was introduced by someone in a position to influence how others in the system would perceive me. Once that happens, once it creates a foundation for everything else that builds on, because each new reference, each new discussion, and each new action is layered on top of the existing characterization that's already been established, layer upon layer upon layer. And when the characterization is repeated across officials, across departments, and across time, it begins to function as more than just a description, right? It becomes justification. It becomes a way to explain actions that are taken, and a way to dismiss concerns that are raised, and a way to frame the individual as the issue rather than the conduct being challenged. The record doesn't show that I've been found to have engaged in conduct that would justify these descriptions, and yet the descriptions persist. The persistence is what makes it significant, because it shows that the narrative's taken on a life of its own, independent of any factual finding. And when you place that alongside everything else, the repeated investigations, the repeated mentions, the repeated actions, the repeated public framing, the role of the language becomes clear. It's not just background noise. It's part of the structure that supports everything else. It's the lens through which I'm viewed. And once that lens is in place, it affects how everything subsequent interaction is understood. That's why it matters that it started where it did, and that's why and that it continues long after the person who introduced it is gone, because it shows what began as one individual's characterization became something that moved through the system and stayed there. And once it stays, it stops being about who said it first. It becomes about, how it's used. You know, I seem to find that it just seems like every single time I get a win, I get hammered with another attack, right? And all of this sucks up public resources, mine included. That raises a direct question about how public funds are being used and whether those funds are being directed towards serving the public. My most recent story shows how much, $545,000 of tax dollars gone to defend and utilize lawyers on the outside nature to help, solidify our city. It's just insanity that we're spending that much money on legal fees. But, you know, I've discussed the fouling incident, and I mean the carry on fouling incident. I've discussed it at nauseum, telling people how they could have retreated into the back office. That was an exit. I'm not going to explain myself anymore. The video clearly shows that I was already in the door threshold when it hit me from the back side of my body, and all of that is clear as day. There was an open office behind he could have gotten into. He could have, left from the front of the door. You clearly see Tony Demakia's hand pushing into, or arm pushing into, Carry On's body, and there's a serious indent, yet not on me. The sequence shows separation, not pursuit. And then that final moment that ties everything together. When I exited the building that night using the only available path to the exit, which is out and out through the front door, lo and behold, everyone's standing there in a circle jerk around the front door. That's where the earlier choices, the later choices intersect, because at that point, the interaction had already ended once. There was no reason for it to restart. Karen had already left the hallway, and I had already remained behind. I had engaged in two separate actions, first speaking with Demakia and then with the chief. The only reason for a second interaction with Karen at that point would be positioning. And the positioning is critical. He was not just passing through. He was not continuing on his way. He was in front of, down in the hall when we were exiting. He was right across from the door of the exit walkway, the only exit walkway, from that room. And then when I was leaving the building, he was standing in front of the only exit leaving the building. That's not, an unavoidable coincidence when you consider the sequence that led up to it. The interaction had already ended once, and yet it was recreated at the only point where it could not have been avoided. From there, the same pattern repeats. Rinse, wash, repeat. Instead of stepping aside, instead of allowing me to exit without interference, instead of continuing on his way, the vehicle, he remained in that space. Then came, when we were down by the hallway door, he could have avoided me, could have done anything. Instead, he sets his stuff down, comes over, and shuts the door on me. It was avoidable. And then we get a new creation of a new one after the original ended by him not leaving when he could have. It could have ended when I went to speak to Fallon, and that could have been the end at the exit simply by allowing me to leave. Each of these moments was opportunity for separation. Each of these moments was followed by a choice that brought the interaction back into existence. And that's why the sequence matters. But in the grand scheme of things, it all happened on city property, and city property is supposed to be the one place where it's actually supposed to matter, right? And that brings us to the seizure of my phone. I just kind of want to talk about this, but by the time the interaction reached the point where my phone was the focus, the original purpose of this whole stop that they did had already been exhausted. What began as a minor lane violation produced no citation, no warning, no articulated safety concern, and all of that remained unresolved. The lawful mission of the stop had effectively concluded, and yet the detention continued without any clearly stated or legal sufficient basis. That shift was not subtle. It was deliberate. It was redirected the entire encounter away from the traffic enforcement and towards the acquisition of my phone. The officer's attention moved directly to my phone. It's not part of a general inquiry or safety related check. It was targeted. The point that the nature of the encounter changed in the way that carries constitutional significance. A traffic stop, even when lawful, at its inception does not provide open-ended authority to pursue unrelated investigative objectives. When that shift occurs, it must be supported by independent legal justification, and none was provided there. The legal importance of that shift becomes even more pronounced when the object of the question is a cell phone. In Riley v. California, the Supreme Court recognized the modern cell phones are fundamentally different from physical items as a person might carry. They contain extensive personal data, communications, records, location information that collectively reflect the most private aspects of an individual life. Because of that, the court made clear that accessing or seizing a phone is significant in the Fourth Amendment events that would require strict adherence to warrant procedures. What occurred in this situation did not follow those procedures. The officer took my phone before the warrant was properly presented. There was no opportunity to review a document beforehand, no explanation of its scope, no confirmation that existed in the form that could have been verified. The seizure occurred first, and any reference to legal authority came afterwards. The sequence is not consistent with how warrants are meant to be functioning. A warrant is supposed to authorize the intrusion at the moment it happens, not be introduced after the fact as justification. After my phone was already in the officer's possession, he briefly held up what he claimed to be the warrant. What was shown was not clearly identifiable legal document presented for inspection. It appeared to be papers inside a file, displayed in a controlled manner, and only for a moment. I was not allowed to approach, to read, or to verify what was being shown. The document remained entirely in the officer's control. When I asked to inspect the warrant, the officer refused the request. The explanation given was that they were concerned that the document might be destroyed by me. That explanation doesn't align with the function of the warrant. Under the Fourth Amendment, a warrant is not treated as a fragile evidence that cannot be viewed. There are copies of it. It's the very instrument that defines the limits of the authority being exercised. Denying me the ability to review it removes the transparency that's built into the constitutional process. It's also important to emphasize that the phone had already been taken before this brief display occurred. The claim of a warrant did not precede the seizure. It followed it. At the point of the encounter, I made my position clear to every officer present. I informed them that their actions were in violation of my civil rights and that they had been an obligation under the oath to uphold and protect those rights. This was not a refusal to comply or an attempt to interfere. This was a direct statement grounded in the constitutional framework that governs their authority. Officers are not empowered by the law. They are constrained by it. Not only, empowered by it, they're constrained by it. And they are sworn to operate within those constraints. The statement did not alter the course of their action. They continued to proceed based on asserted warrant, and they had not been properly presented and had not been made available for inspection. I requested to retain possession of my phone until a supervisor could arrive and properly present the warrant. That request was tied directly to lawful procedure, and it was an attempt to ensure that the process being followed met constitutional requirements. That request was denied, and the phone remained in his possession. The nature of the seizure also matters. How it's evaluated. It's not a situation where officers encountered the item incidentally during a lawful search. The phone was the objective. Their actions were directed towards obtaining it. That kind of targeted conduct is directly relevant under United States v. Jones, where the court emphasized that physically taking control of property for the purpose of obtaining information constitutes a search within the meaning of the Fourth Amendment. When that action is intentional and information driven, it must be supported by proper legal authority at the time it occurs. The requirement was not satisfied here. Eventually, a supervisor arrived on the scene, and at that point, I was provided with what was described as my copy of the warrant. The timing of that presentation is important because it confirms that the warrant was not used to authorize the seizure at the moment it occurred. Instead, it was introduced afterwards, once the phone had already been taken. When I reviewed the document that was provided, it was presented an additional and significant issue. The warrant stated that it was supposed to have an affidavit that was incorporated herein and attached, and the language indicates that the affidavit is not separate from the warrant, but forms part of it, supplying the factual basis for the probable cause, and in many cases helping define the scope of what's authorized. However, no such affidavit was attached. There were no additional pages accompanying the warrant, no sworn statement, no factual narrative. The document explicitly referenced incorporated and attached affidavit that was not present. That absence is not a minor defect. The warrant must be complete either on its face or through properly incorporated and physical attached materials. If an affidavit is relied upon to establish probable cause, it must be available as part of the warrant at the time of its execution. Without it, there's no meaningful way to evaluate the basis of the inclusion or the intrusion on the limits of what has been authorized. The concern is consistent with the principles outlined in Carpenter v. United States, where the court reinforced that digital data is entitled to strong constitutional protections due to the depth and sensitivity of the information it contains. When law enforcement seeks access to the data, the legal authority must be clear, specific, and properly executed. An incomplete warrant that references but not include its supporting affidavit does not meet that standard. The full sequence of events reflects a consistent pattern. The focus of the stop shifted away from its original purpose without articulated justification. The phone was identified as the target and seized before any warrant was properly presented. A document was briefly displayed but not made available for inspection. My request to review the warrant and wait for proper presentation was denied. I informed the officers that their actions were violating my civil rights and reminded them of their obligation under oath, yet the conduct continued unchanged. Supervisor later provided a document that was incomplete on its face, despite stating that it was incorporated and attached to an affidavit. Shortly after that, I was told I was free to leave. Taken together, these actions reflect a process in which the constitutional safeguards associated with the warrants were not followed in sequence, were not made transparent, and were not applied in a manner that actually allowed for verification at the time of the intrusion occurred. The authority that was claimed was never properly demonstrated at the moment it was exercised, and the documentation later provided that it did not resolve that deficiency. Context, character, and what's being said, there's something that needs to be addressed directly because it's been allowed to circulate without challenge and it has nothing to do with the facts. In the same time period as this incident, there are reports of racist letters targeting Puerto Rican members of this community. That conduct's unacceptable. I'm just going to say that out loud, folks. And it's not political. It's not debatable. It's wrong. And it deserves to be investigated and taken seriously. What's equally unacceptable is attaching my name to that kind of conduct without any single piece of evidence. I'm not going to respond to that by, softening my position or speaking in vague terms. I'm going to state clearly and cleanly who I am, where I come from, and what I stand for, because that record already exists, whether people choose to acknowledge it or not. I was raised in California by a mother who identified as a Democrat in an environment where civil rights were a part of everyday life. I remember as a kid watching the farm workers march in Bakersfield. That experience stayed with me. It's not about a single figure or personality, and I'm not going to center it on one here. It was about seeing people organize, stand together, and demand to be treated with equal dignity. My life reflects that same, reality. My fiance is of Hispanic. My first fiance was of Hispanic descent. My wife, who I eventually married, carried the last name of Garcia. God rest her soul. And the mother of my daughter comes from the Zarate family. These are not distant associations or convenient statements. These are the people I've built my life with, the people I care about, and the people who are part of my family. My campaign manager was Puerto Rican. My views have been consistent across communities. I support African American rights. I've spoken openly about disparities in incarceration rates and how disparities shape what people are perceived and treated. I support the LGBTQ community because dignity and equal treatment are not conditional. Those are not positions I adopted recently. They are not positions that shifted based on convenience. Politically, I identify as a Republican for one reason and one reason alone. I support the Second Amendment. That's the issue that places me there. Outside of that, my views align more closely with libertarian principles, particularly when it comes to limiting government overreach and protecting individual rights, but more towards constitutionality or constitutionalism. And that's exactly where this becomes clear. I believe in the rule of law. I believe it's illegal to be in this country without documentation, and I support lawful immigration. Many people connected to my own life, including members of my daughter's family, came here through that process, and that matters. But the Constitution also doesn't become optional depending on who the government is dealing with. Due process is not selective. It is not reserved for certain people when ignored by others. It matters in a traffic stop. If it matters in my traffic stop in Lorain, then it matters on the street for anyone. If I'm going to argue that for me, I'm going to argue it for everyone. That is not a political position. That's a constitutional requirement. What I've seen of immigration enforcement, and particularly from ICE, reflects a pattern that raises serious concerns about training, accountability, and respect for those constitutional limits. When enforcement crosses into disregarding due process, it stops being about law and starts becoming unchecked authority. And I don't support that. I do not have to agree with someone on every issue to recognize that when constitutional lines are being crossed, I may not align with the royal politically, but if the issue is standing against violations of due process against ICE, then I'll stand there with him without hesitation. Because it's not about party loyalty or whatever it may be. It's about whether the Constitution is being applied consistently and equally to all. Not only when it's convenient, but also when it's inconvenient. Some people attempt to attach my name to racist conduct. They're not just wrong. They're ignoring everything that's publicly known about my life, my relationships, my positions. There's no evidence connecting me to those acts. None. There's only speculation, and speculation does not become part of the truth because it's repeated. I am accountable for what I've done. I am responsible for what others. I'm not responsible for what others choose to assume. Civil rights notice and repeated failure to comply is where we're going to end up next, and that's where we have occurred in this situation. Understood as isolated interaction between an individual and law enforcement. This is a sequence of events, and where government actors were provided with clear notice, given multiple opportunities to comply and establish legal obligations, and they just didn't do it. I did not encounter this system without preparation or without having taken steps required of me under the law. I disclosed my disability in writing. I submitted a formal request of accommodation. I identified the nature of my condition, specific adjustments needed to allow me to participate safely in public meetings. And that request was directed to the appropriate officials within the city, including those responsible for oversight and compliance. And there was zero response. There was no acknowledgement that the request had ever been received, no engagement, the substance of what was being asked, no attempt to implement even the most basic of accommodations. That absence of response is not neutral. Under Title II of the American Disabilities Act, once a public entity is placed on notice of qualifying disability and a request of reasonable accommodation is made, a legal obligation is triggered. That obligation requires action. It requires evaluation, communication, and implementation where appropriate. It doesn't permit silence, and that's still what we're getting today. What followed was not just an initial failure to reflect on the correction, it reflected continuation. During the public council meeting, I was subjected to direct unnecessary confrontation by a city official, Mr. Carrion. That confrontation was not incidental. It occurred after notice had already been given. It took place in a manner that aggravated the very condition that had been disclosed. So I addressed it again with another letter. The incident was serious enough that it resulted in a formal ADA Title II notice violation being issued to the city by a disability advocate, Jay Shore. That notice outlined the legal framework, identified the failures that had already occurred, and provided the city with defined opportunity to correct its conduct and come into compliance. At that point, the situation was no longer ambiguous. The city had been informed and in writing of its obligations and had been made aware of its consequences of its inaction, and had given a clear path to address the issue. Now, Jay Shore, an ADA advocate, later reinforced those points to direct communication with the city, clarifying the obligation to accommodate does not depend on repeated verification demands, and that the protections of the statute were intended to be applied broadly. And the advocate also identified that the conduct involving intimidation or interference with the person exercising ADA rights itself is prohibited under federal law. Taken together, those communications established a record that is difficult to misinterpret. The city was aware of my status as a qualified individual with disabilities. It was aware of the accommodations requested. It was aware of the prior conduct, had already created a hostile and aggravating environment, and it was aware of the legal standards governing the responsibilities. And what it did was not comply, and that's where the sequence becomes important. I didn't withhold information. I didn't create a situation in which the city was left to guess at what was required. I told them, provided notice, provided documentation, and I allowed time for a response. That was not done as a tactic. It was done in good faith with the expectation that the system would operate as it's designed. The result was not compliance. The result was continuation of the same pattern. When a traffic stop occurred, I disclosed my condition. I informed them of the PTSD. I requested accommodation. The request was consistent with what had already been communicated through formal channels. Did not introduce new information. It reiterated existing notice, and it was ignored. The interaction did not reflect adjustment for awareness. It escalated. The stop extended beyond its original purpose. I was ordered out of my vehicle under threat of arrest. I was subject to physical frisk that involved close, forceful contact. The handling of my person and property occurred in a manner that increased tension rather than reducing it. Multiple officers were present, and the environment became controlled in a way that left little room for de escalation. At no point in that sequence was there any indication that the officers were acting with regard for the condition that had been disclosed, or for the prior notice that had been already given to them and the city, to the same public system that they represent, right? This is not a question of whether a single officer made a poor decision in the moment of uncertainty. This is a question of whether a system that's been informed, documented, and given repeated opportunities to comply chose not to do so. From the perspective of a reasonable person, the pattern is consistent. Notice was given, obligations were established, opportunities to correct were provided, the conduct didn't change. That's what distinguishes this from a misunderstanding. When a public entity fails to act after being placed on notice, and then when that failure is not or is followed by conduct that aggravates the known condition, the issue is no longer whether the law was clearly explained. The issue becomes whether it was followed. In this case, it wasn't. What remains is a record that shows not only obligations existed, but they were brought forward clearly, repeatedly, and with sufficient time to respond. The failure to act on those conditions is not neutral. It reflects a disregard for duties and is defined under federal law and designed to protect individuals in exactly this type of situation. You know, and that's where we get to this point. Like, some point we have to look at the fact that oh my god, a long one tonight. I'm gonna skip past this. I think I overshot my want. I don't want to doze off in the middle of another one. In this section, I'm just talking about all the October 20th stuff that went down, and the issue that came with it, the publication that came along with it, and and that's going to bring us to our segue to our final thought. When you stop looking at these events as separate incidents and instead watch how they unfolded over time, what emerges is not confusion, and it's not coincidence. It's not a series of independent mistakes made by different people at different moments. What emerges is continuity, not just in what happened, but in how each step leads directly to the next without interruption, without correction, and without any meaningful attempt to stop it from unfolding. Because in a functioning system, friction exists. Something gets challenged, the system slows down, a complaint is filed, it's investigated, a record is disputed, it's corrected, authority is exercised, it's justified before it's carried out. That friction is what protects people. It's what prevents escalation. It's what forces accountability before harm compounds. The friction is absent here. Instead, what you see is forward motion. A complaint does not trigger investigation, it triggers positioning. Information is not clarified, it's shaped. Statements are not verified, they're repeated. And once they are repeated, they begin to carry weight, not because they are true, but because they exist in the system. That's how a narrative forms, not through proof, but through repetition inside structures that give them credibility. And then from there, the process takes a life of its own. Actions are taken out to resolve uncertainty, but to reinforce what already has been assumed. The warrant doesn't appear out of the result of transparent or reviewable process. It appears as something already decided. Where the supporting material is not made available at the time it's used, the seizure of property does not follow the representation of authority. It precedes it. The justification is not what drives the action. The action comes first. The justification is constructed around it afterwards. And that reversal matters because it changes the nature of what's happening. When authority is used first, the explained later, the process is no longer a safeguard. It becomes a tool. And at the same time, the written record, the thing that's supposed to anchor everything, is in fact starting to drift away from it actually occurred. not in a way that can be dismissed as oversight, but a way that consistently removes context, removes initiating conduct, preserves only what supports a particular version of events. That version is then published, maintained, and left in place even after direct notice to them and contradictory evidence is provided. That's not how errors behave. Errors get corrected when they get exposed. They do not persist in the same direction after being proven wrong. And while all this is happening, the people involved are not stepping back to examine whether something is broken. They're preparing to defend what's already been done, individually, formally, with counsel, while others with the same structure approve these defenses. This is not behavior of the system discovering a mistake. It's behavior of a system bracing for a challenge. And when you step back far enough to look at the full record, another pattern begins to emerge. That cannot be dismissed as coincidence or overlap. My name does not appear once or occasionally or in passing. It appears repeatedly across complaints, internal communications, public meetings, official documents and records, and now across multiple legal proceedings. It's referenced by local officials. It's in different roles, different stages, always in the same direction. The level of repetition is not consistent with ordinary interaction between a citizen and a municipal system. It reflects sustained focus, and that focus is paired with everything else that's already been laid out. With the failure to investigate, the refusal to correct records, the escalation instead of resolution, and the preparation for legal defense instead of accountability, it stops looking incidental and it begins to look structured, because repetition on its own does not mean anything. Repetition combined with direction and combined with outcome begins to show something entirely different. It begins to show the same individual is not just present in the process, but is also being carried through it step by step without deviation, without interruption, without correction, and the outcome starts to appear less like a result and more like something that was always going to happen. Preconceived outcomes. And when you step back and look at how that plays out, not in theory, but in sequence, it stops looking like independent decisions and starts looking like alignment. Not necessarily because the actor is coordinating in a deliberate way, but because each outcome is the same. Each action supports the next. Each step reduces the chance of reversal, and each layer makes it harder to unwind what's already been set in motion. Because in a system that's working the way it's supposed to, the process is what protects you. The process is what stops things from going too far. The process is what forces correction when something breaks. Here, the process is what's carrying it forward, and it's what they're trying to use to break me. And when the process itself is what's producing the outcome, when every safeguard designed to step in place and stop it, when every opportunity to correct it becomes another layer on top of that added to the top, that question is no longer whether something went wrong at a single point in time, but the question becomes whether you are watching a system making mistakes or a system building a case around a person. And once that question is clearly in front of you, there's only one thing and one place left to go. And at the end of this, after all the complaints, the records, and the filings, after the warrant, after the stop, after the seizure, after the refusal to correct what's provably false, what remains is not a misunderstanding. What remains is a system of actors identified by name and by role, operating sequence, each step reinforcing the last, and each step raising its own legal exposure, folks. Joseph Levesque, assistant law director, placed on notice of constitutional violations, ADA obligations, and procedural defects, and instead of correction, the response was silence, followed by preparation for defense. Law Director Riley was equally positioned to intervene, equally placed on notice, and equally responsible for ensuring that actions of the city and its agents, Jesus, hot back here, sorry, remained within the bounds of the law, but that didn't occur. Chief James McCann, as the head of the police department, was responsible for ensuring that complaints of misconduct were investigated in accordance with the department policy. Complaints were filed, retaliation alleged, obligation to act was clear. No meaningful investigation followed. And again, Mr. Galinas, sergeant, captain, lieutenant, whatever the fuck he is today, was busy working his way up through that department the entire time. So his failure is McCann's failure. Lieutenant Thompson involvement prior to the traffic stop, when entry into City Hall was denied under threat of arrest despite notice of rights being requested. It didn't stand alone. It forms the same pattern where authorities are sorted first and justified later, where accompanying compliance is demanded under threat of arrest rather than granted in lawful process. Fouling in connection with the warrant and the execution was responsible for ensuring that authority was properly established before it was exercised. A warrant that references an affidavit must be capable of being reviewed. Authority cannot be asserted in a place of being shown. The seizure of property prior to meaningful presentation of that authority raises direct questions under established Fourth Amendment law. I'm going to have to stop really quick just because I'm burning up. I'm going to. Sorry about that. My brother keeps the heater on in this place, and it just got really hot back here really quick, and I had to go open the back door. But the officers present at the roadside are not identified here by name because I haven't, got them yet. But what they did was definitely in question under the Fourth Amendment and the 14th. Each officer present was operating under oath, under policy, and under constitutional limits. The prolonged detention, the escalation beyond the purpose of the stop, the physical handling, and the targeted seizure of my property occurred in the presence of multiple officers. Regardless of the individual's identity, each individual officer present had the same obligation to act within the law and the same opportunity to intervene. No intervention occurred. Bradley, Carry On, sitting on the control board, they're not outside observers. They participated in approving legal defense for individuals named in the same body of conduct. City Council as a whole was not uninformed. Notice was given, documentation provided, the issues raised, including inaccuracies in official records, failures of process, and ongoing disputes regarding conduct, were placed directly in front of those holding legislative authority. The clerk of council was placed on notice regarding inaccuracies in the official minutes and provided with evidence contradicting the published record. That record remains. It continues to exist as an official representation of events that has been challenged with supporting evidence and not meaningfully corrected. And this extends beyond individual titles. Every individual operating under the oath of office was notified, whether they through direct communication or through formal complaint or documented filing, carried an obligation, not a discretionary one, a legal one. The obligation to act within the Constitution, the obligation to correct what was known to be false, the obligation to intervene when violations are occurring in real time, the obligation to ensure that the authority they exercise is lawful, justified, and transparent. Those obligations were not met. And while those obligations were being ignored, the conduct continued. A traffic stop initiated for a minor traffic violation that did not end with a violation. It was extended beyond its lawful scope, raising direct issues under Rodriguez v. U.S., a pat-down conducted in a manner that exceeds the scope of Terry, a cell phone seized before a warrant was properly presented implicating Riley v. California and the heightened protections afforded to digital data, authority asserted being meaningfully shown, action came first, justification followed, and at the same time the record of events was being shaped, an official government document was created that omits material facts, alters sequence, and assigns responsibility in a way that conducted by independent evidence. That record remains published after notice. That raises direct questions under Ohio law regarding falsification, tampering with records, and compliance of the Open Meetings Act and the Public Records Act. ADA accommodations were requested, documented, and ignored, raising issues under Title II with American Disabilities with Act. Complaints were filed but not investigated, raising questions of retaliation under both state and federal law, including 42 U.S.C. 1983. And none of this stands alone because the same individual is referenced again and again and again and again across complaints, across communications, across records, across enforcement, across legal response, not randomly, not occasionally, but consistently, directionally. This is not a coincidence. This is focus. What also cannot be ignored is that none of this required a single person acting alone. It required participation. It required presence. It required people at multiple levels seeing what was happening and allowing it to continue. Because at any point in the sequence, at any level, someone could have stopped it. Someone could have required justification before action. Someone could have corrected the record, but it didn't happen. Participation is not limited to action. It includes allowance. It includes silence in the face of obligation. It includes standing in a position of authority under oath and choosing not to intervene when the law requires it. All those officers on the side of the road, I will have your badges. And when that silence exists across multiple levels, across enforcement, legal counsel, and elected authority, it extends responsibility rather than eliminate. You guys followed, your orders or whatever from your boss rather than actually doing what your oath requires you, and that is what's going to lose your badges. That's the 1983 violation. You had a constitutional right to protect me, and you didn't. And that's why I gave you an opportunity, just one of you, to have a set of balls. But instead, apparently, Fallon's got them all in his pocket or his mouth. Apparently, you can say that. So as long as nobody believes that Fallon's mouth is a ball sack, you can insinuate that all his officers' balls are in his mouth because it's not reasonably articulately believable. Unless he says, "Oh, I don't know, maybe," but without interpretation or correction, it stops being explainable as coincidence. It starts to look like direction, and that same name, the same focus, the same progression carried forward step by step by step through the system and never resets. And when that individual is a veteran, when accommodations have been requested, and when conditions have been disclosed, and when the disclosures are ignored while escalation continues, the question becomes even more direct because the law does not allow for selective application. Rights do not exist only when convenient. They either apply or they don't. What is also a serious concern is the role of the judiciary within the same structure. Judges are not participants in enforcement. They're not aligned with one side or the other. Their role is to remain neutral and act as independent check for the use of authority. That independence isn't optional, it's foundational. And yet statements have been identified within local law enforcement that has been describing local law enforcement as partners. That language matters because the court is not supposed to be operating as a partner to enforcement. It's supposed to operate as a restraint on it. That concern is not abstract here. Multiple judges have recused themselves. Recusal is not routine. It occurs when impartiality could be reasonably questioned. When that happens more than once, it signals that the issue is not isolated. It signals recognition within the system itself that distance is required. And when those facts are viewed together, the relationship between enforcement, review, and recusals, the conduct, the lack of correction, it gets that broader question going about whether the safeguards that are supposed to exist are actually existing in place and functioning the way they're supposed to. Because the court is the last safeguard. When everything else fails, it's supposed to stand apart. And when the perception of that independence is questioned, it becomes part of the same pattern. And there's one more question that cannot be ignored because it cuts through everything else that's been said. If I am what they claim, if I am wrong, if I am dishonest, if I'm unreliable, then why does this continue at the scale and at this level? Why does my name continue to appear across court filings, across official records, and on the front page of the Chronicle on the only day they print? If they're not afraid of me, why does this not resolve, correct, or disappear the way unfounded claims typically do? Because that's not how it's supposed to work, right? Actually, that is how it's supposed to work. Because something lacks substance, it will collapse under review. It doesn't expand, it doesn't repeat, it doesn't persist across multiple systems at the same time. And yet, here I do. It does. It is. It appears in court, it appears in official records, it appears in the paper not once, but 16 fucking times. To the point where it becomes part of the public narrative itself. And by it, I mean me. And when the exposure includes images taken from published under circumstances that raise their own legal questions, why the Chronicle is taking pictures against the court orders and then publishing them not once, not twice, but 3 times, not resolution, no correction, no expansion, just nothing. That contradiction matters because if this were as simple as they suggest, it would not require this level of continuation or this level of coordination to attack me. It would not require this many actors, this many records, and this many proceedings to sustain it. So the question is not whether my name appears. The question is why it continues to appear in the same direction across the same systems without resolution, without correction, without stopping. And once that question is asked honestly, it does not point backwards. It points forwards. Because in a lawful system, evidence leads to action. Here, action led to justification. In a lawful system, records reflect reality. Here, reality is forced to compete with the record. In a lawful system, complaints trigger investigations. Here, complaints triggered resistance. So the question is no longer whether something went wrong. The question is how many people saw it happening and chose not to do a damn thing about it or stop it. And more importantly, who among those people were sworn to uphold the law allowed it to continue anyway? This didn't happen by accident. It happened because nobody stopped it. With that, I thank you guys for tuning in tonight. This has been Unplugged with Aaron Knapp. law enforcement be lawful, not awful. And for those of you that are watching, I appreciate you tuning in. Feel free to donate. Feel free to check out our sponsors, and we'll see you guys next time. Try not to get arrested by your local law enforcement or Lorain PD because they will violate your rights.